Speak English, sir.
Yes, English.
Mr. Castro, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you
Notice how quickly the judge lays out the Miranda-style rights. This isn't just some routine formality. It's a legal shield built to protect the process and make sure the defendant knows exactly what's at stake. The second Castro opens his mouth, anything he says can and will be used against him in court, no matter how small. It's a chilling reminder that in this room, every word carries weight and consequence. If you were in Castro's shoes, would you stay silent and cautious or risk trying to talk your way out?
know will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 3rd, 2025, in Harris County, Texas, a law enforcement officer reviewed information about a street takeover event and went to the location that was put on social media. The law enforcement officers conducted surveillance on the location in an unmarked vehicle and witnessed a vehicle making donuts and get within close proximity of several parked occupied vehicles. Law enforcement officer initiated a traffic stop on the vehicle and detained the defendant, the driver of the vehicle making donuts.
Any prior reckless driving cases, and then can you see if he has a license, please?
There are no prior reckless driving cases, Judge. There was a DWI and an evading vehicle at Hidalgo County. Just
At Hidalgo? Okay. Anything else?
and driver.
Okay. Mr. Castro, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to participate in this activity anymore or drive recklessly, maniacally. If I find that you do, the first thing I'm going to do is put you in jail. And the next thing is I will take your ability to drive away from you while this case is open. Do you understand?
Yes, sir.
Living in a city as big as Houston without the ability to drive blows. Not only that, people who participate in these types of activities, cops and DA's office can seize and take your car away from you permanently. And I've seen it happen on multiple occasions where people lose their $100,000 car because they. Do you understand?
Sir.
You put bond conditions, no donuts, street takeovers, reckless driving, racing, etc. Please. Mr. Castro, do you have the ability to hire a lawyer? We're going to give you time. So I'll have you go to Ramona, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign the bond conditions. After that, we'll let you go. When you come back, please have a lawyer.
Judge, I apologize. Did you say no driving or just no
No,
reckless?
no reckless driving, donuts, street takeovers, racing, and all that. Is it Taishika Jackson?
Yes, sir.
Man, you're charged with assault of a family member. You're facing up to a year in jail and or $4,000. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. But you're right to remain present if you cannot afford one.
Okay.
Thank you, Judge. On March 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. The officer met with the complaining witness who stated that the defendant is from a roommate. The complaining witness stated that they got into an argument over a broom and the defendant struck her on the head with the broom, causing pain. The officer observed a raised bump on the complaining witness's head that was starting to become discolored.
Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this complaining witness. You're also ordered not to be in possession of weapons. If you violate this order, I'm going to put you in jail. No more PR bonds. Do you understand, ma'am?
Yes, sir.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they can file additional charges against you, a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? It's one of the worst cases you can pick up. So don't violate the protective order.
Okay, yes, sir.
Okay. Do you have the ability to hire a lawyer?
No.
Okay. I can appoint you a lawyer or I can have you fill out an application. Let me see if you filled one out first. Hold on. I have an application on file already. I have one on file. So what I can do is I can appoint you a lawyer today. We're going to create bond conditions for you. Do not leave until you sign those bond conditions. Otherwise, I'll issue a warrant. The bond conditions, no contact, no weapons.
Okay,
All right. For now, I'll have you go to Ramona, sign a reset, and then we'll have you take your seat in the jury box.
okay.
All right. Good morning, Mr. Gomez. So he's got two cases, right? The trespass
Judge.
and the
They're
DWI?
getting a time served to the DWI. They're dismissing the criminal trespass.
Boom, did you catch that? 20 years. And because of the 3G offense, Gomez wouldn't even be eligible for parole until half of that time is served behind bars. That's the kind of brutal reality check that makes even the boldest defendants suddenly very cooperative, realizing how serious their situation really is. But here's the kicker. Every new case he picks up is basically fresh ammunition for the system to use against him later. With that in mind, how many real chances should someone get before the hammer of justice finally comes crashing down hard?
Now, if I'm correct, you're on felony probation in another county, right?
Yes, Your Honor.
Is it?
It's Bear County, Judge. It's aggravated robbery.
You're looking at 20 years in prison, not only that, it's a 3G offense, meaning that if they revoke you and send you to prison, you have to do half the time before you're even eligible for parole. So if they send you to 12, you're doing 6 before you're even eligible. Now you got these two cases. When is it going to register to you that we mean business, that you can't continue like this, unless you want to go to prison, of course. You need to understand that by pleading guilty to these cases here now, they may use this to revoke your probation in Bear County. Do you understand?
Your Honor.
Now, I don't know if they're going to, but they can. And I'm going to tell you, the more cases that you pick up, the higher likelihood you have of that happening, because they are going to be like, well, this guy just, doesn't take us seriously.
Your Honor.
You are giving up a lot of rights by entering into this agreement, Mr. Gomez. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you're done with this. You can never come back and change this or undo this. When you're in a car and you're driving and you get pulled over, the first thing an officer does is they look at your criminal history. If they roll up to your car, they look at and they see that you're on probation for an aggravated robbery, you have been charged with a trespass and a DWI, and they come up to you, you think it's going to go well? So I probably wouldn't give them the ammunition from now on. If you want to get lit, don't get into a car. Even if you've had a sip of alcohol, you understand.
Yes, Your Honor.
As part of the agreement, it's 20 days in jail on the DWI, 16 days credit, and they're going to dismiss the trespass. Is this how you understand it? You also, I'm going to make a docket notation that I have advised you that by pleading guilty to these offenses, it's possible they revoke your probation in Bear County. Do you still want to do this, or do you want to wait to see what happens over there?
To do this.
You want to do this?
And he's been in communication with probation over there, Judge. And basically, they gave him the option of either being unsatisfactorily terminated. Is that correct, Mr. Gomez?
Yes, unsuccessful.
Or he could have it extended and attempt to get it successfully terminated. And so he chose to have it extended to pursue that option. And they were already aware of these cases, correct?
Yes, Your Honor. Yes.
How do you plead to the driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to the agreement. I'm going to suspend your license for 180 days. Do not drive. Otherwise, you're going to be right back in jail.
Sure.
All right? Good luck, sir.
Thank you, Judge.
Good morning, Mr. Reyes. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On April 4th, 2025, in Harris County, Texas, an individual notified officers of a motor vehicle stopped on the roadway. The officer observed the vehicle stopped in the intersection between two lanes. A traffic stop was initiated, and the officer observed the defendant behind the wheel, leaning over, with his eyes closed. The officer woke up the defendant, and the defendant did not acknowledge the officer's knocking on the motor vehicle, and the motor vehicle began to move. The motor vehicle fled for approximately 2 miles, stopping in front of a residence. The defendant exited the motor vehicle and was handcuffed. The defendant stated he did not see the officer with lights on behind him. The officer observed the defendant come to a complete stop in designated areas to properly use turn signals. The odor of alcoholic beverage was emitting from the defendant's person. The defendant stated he drank 3 to 4 beers. He was identified by his Texas driver's license, and on the standardized sobriety test, the officer observed 6 out of 6 clues on the HGN, walk and turn, and 2 out of 4 on the one leg stand. Defendant considered to do a breath test and blew 0.15 and 0.147.
Okay. Any prior DWIs?
No, Your Honor.
License?
Eligible, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, you pick up a new case, you become a danger to my city, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance. That's also a condition of your bond. You have a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Zaman. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You understand your conditions?
Yes, sir.
I'll have you go to Ramona, sign a reset. We'll have you get with Fleisher for your bond conditions, and then you're free to go.
Thank you, Judge.
Please. So you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 4th, 2025, in Harris County, Texas, officers were dispatched to a traffic hazard call. A motor vehicle was stopped on the shoulder of the freeway, slowing down traffic. The officers observed the defendant sitting in the parked motor vehicle, and the defendant admitted to driving the motor vehicle to the location and being its registered owner. The officer detected a mild odor of alcoholic beverage, clear, glossy eyes, and that the defendant was not sitting on. Standardized sobriety tests were conducted, and the officer observed 6 out of 6 scores in the HGN, 1 out of 4 on the one leg stand, 2 out of 8 on the walk. The defendant refused a breath test initially, and then eventually consented to a breath test. The results of which were 0.118 and 0.132.
So he's just sitting in a parking lot? Does an officer see him at all when?
Sorry, Your Honor, he was stopped on the shoulder of the freeway.
Oh,
slowing
okay.
down.
Got it. All right. Okay, Mr. Weishuhn, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now, does he have a valid license?
Yes, Your Honor, he does.
I'm now placing a restriction on your license. I'm now ordering you not to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand? I don't care what you have to do, where you have to go. If the car doesn't have an interlock, don't drive it. We are sending notice to DPS in Austin so that every single officer in this state knows. So if you get pulled over, they're going to know that you need one. If you don't have one, they're going to take you to jail. I'm also ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. Because you have a lawyer.
He already has the interlock on the car, Judge.
Great. Okay, so just provide proof to them, or they should be able to look it up, and then we're all happy. Just don't use. You understand? Because you
Judge.
have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr. Bresson. He'll tell you if and when you have to come back to court. If you pick up a new case, if you're a danger to my city, if you just, it's not going to go well for you. Do you understand? Okay, guys,
Thank you, Judge.
please.
Permission to approach.
Yes, please.
Your Honor, I'm here on Shamar Anderson.
Okay.
So I just wanted to approach on this one. I was talking to the coordinator. It is an older case.
It's 370 days old.
So he doesn't live in Harris County, Your Honor. And so that's what really kind of has led to the delay. So I just got appointed today. I would ask for at least 30 days to be able to review everything.
I mean, I'm not going to, this case is 400. He's taken off on multiple occasions. Is there an offer in this case?
There is a time served, Your Honor.
Is that it?
They haven't talked to the complainant, Your Honor. They haven't called the complainant.
We've not made contact with the claimants, Your Honor.
Hey, I'm getting my ass chewed because of all these cases that are so darn old, so no more. So I'll give you guys 2 weeks. You need to get in contact with the complaining witness if it's needed, because I don't know.
It is late.
So you've got 2 weeks,
Yes, Your Honor.
so no more. So get on it, and then he's got to be back in 2 weeks, and it's clear trial on that day.
It's plea or trial that day?
It's 370 days old. I mean, really, I have to say when at some point. I can't just keep letting it go.
Well, can I ask you this, Your Honor? Since he does live in San Antonio, if that is our, can we get 3 weeks?
Come up.
I just want to make sure, I don't want to create an issue with him and his travel. So I just want to be clear with the court. I understand, Your Honor.
Literally, Mr. Anderson, you literally bend over backwards to not put people in jail. Your case is nearly 400 days old, and it's time to make a decision on what to do. I'm not going to sit here and play any more games.
Yes, sir.
2 weeks for you guys to meet to decide what you want to do with this case.
Sir.
But at 370 days, that's it. Cases should be resolved at 180 days.
Sir.
Do you understand?
Sir.
So be back here in 2 weeks. Let us know what you want to do. You must meet with them to figure out, look at the evidence, see what's out there, and just make a decision. It's not hard. It's a trespass. It's not a capital case, you know? If it was something serious, then yeah, but I mean, it's a trespass. It's not a capital trespass, you know? Okay. All right, guys.
Your Honor, if I may, this stems from a bond violation report here where there's 2 readings of positive alcohol on his portable device that he currently has, Your Honor. I've discussed this at length with our client, and as you may understand, in our experience, we certainly hate to provide any type of excuse whatsoever when it comes down to this. Discusses with our client, he's adamant that this was stemming from consumption of medication during a period where he was unfortunately under the weather, Judge. And he did send me the pictures of the medications that he consumed. It's Theraflu, Dayquil, the typical over-the-counter medications, Your Honor.
None of that is going to test positive for alcohol. You know?
I've admonished him on this, Judge. I made it abundantly clear this should not be something that, should even come out like this way. This is something that we would graciously ask the court here to consider seriously admonishing our client, Judge, but allowing him to remain on bond. I think we're close to a resolution on this case, Judge, and we're looking to hopefully get this resolved as quickly as possible.
Here's what I'm going to do. I'm sending you now for a drug and alcohol test. I've ordered you not to use. We've had pre-trial tell you not to use. And you now have on 2 different occasions tested positive for alcohol. So either you don't care about court orders or you have a problem. I'm sending you now for a drug and alcohol test. You were to come back, and it's now late, so we'll have you come back Monday with the results. Do not use.
No.
Do you understand?
Entiende. Entiende.
Okay, I'm sending him now, Mario, and then we can regroup on Monday, okay?
That'll work, Your Honor. Thank you.
Wow, yeah.
Okay.
You're always
Thank you,
come
Judge.
back here Monday, and I'm sending you for a drug and alcohol test. If you fail to take the test, I'm going to issue a warrant for your arrest. Do you understand?
La su arresto. ¿Se entiende?
You're to come back Monday, and then we'll discuss the results. If you fail to come back Monday, likewise, you will be arrested.
Será registrado.
Okay, take a seat for me, sir.
Basically, Your Honor.
Thanks, Mario. See
Yeah,
you.
we can judge. Take care.
Hi, Mr. Sweat.
How you doing, sir?
How are you?
Pretty good. How about yourself?
What's the word?
Judge, so he's been cleared now.
Great.
Is my understanding. Well, okay. I do have to advocate for my client, Judge. When he first
I'm
signed
not
up,
going to begrudge you for advocating for your client. Absolutely not.
a couple things. When he first signed up, I admonished him. We went through the paperwork. We talked about what to expect. He was expecting a pickup date of April 16th. And so all of a sudden, he wasn't cleared medically for some reason. We
Well,
don't.
because he was allegedly coming down, right?
I don't know who makes that determination.
Well, if you're in a state that it's not an appropriate state for transport,
Right.
he's subject to injury to himself. Transport it's a huge liability for them. So they want to make sure that you're in the right state of mind for when you do get transported. I mean, it's only logical because the last thing they want is to get sued because they try to take you and you're not in a right condition and something happens, right?
Sure.
You know that every time someone comes to transport you from this state to the other, it's, you know, it's $4,000 to $6,000. It's not cheap.
Sure.
Someone has to pay for it, right?
Yes, sir.
A lot of times they'll come after you to foot the bill. So I don't know. But regardless, it's a 30 days, right? He's a Michigander.
Correct, Your Honor.
When are they coming?
They said they can be here with up to 10 days, so the reset date is the first, but they should be.
What is it?
The reset date for this case will be the first, for
Okay.
3 days, but they probably should be here without, thanks, up to 10 days.
Okay, so it's still within the 30, right?
Correct, Your Honor.
Okay. I mean, it's still within the 30, which is what the statute says. So no one's doing anything to you that would harm your interest in any way. We want to make sure that you can be done in a safe and effective way, you know?
I understand.
So hopefully within the next 10 days.
Hopefully, Judge. Yes. Okay.
Okay. He has a pre-signed waiver anyways, right?
Yes, and it was entered on the.
Even if I wanted to give him a bond, I can't.
Judge, the only thing the issue
Signed waiver.
that brings up though is we require him to sign the waiver of formal extradition and everybody signs this.
No. There's a document that I signed ordering
Did Hugh Hunter?
the, for his to be remanded. There's no real formal document for him to sign. It's a document they filed to me and I signed it for him to go get picked up. So theoretically, there's nothing for him to sign.
What I'm speaking of is the actual waiver of formal extradition proceedings that's signed by him, by
They
you.
probably signed that because they didn't see that there was a pre-signed waiver to begin with, a lot of times.
Right. And that's my only issue. When we're talking about this, there's an expectation that he signs this and he gets 14 days. And this is done on all the cases. This is like the fifth time I've had to explain to somebody, hey, it's 14 days. No, it's not really 14 days and we're up here, but I signed the document, but the document says 14 days and I'm looking silly up here because we're talking about 14 days and all of a sudden it's 30 days.
But sometimes you're not going to get the document that there's a pre-signed waiver until after the fact as well. It's not that you don't look silly. You just need to advise them, hey, sometimes we documents after the fact. And that's just the way it goes, you know? Not everything is done, 100% every single time.
So there's not an extension on the waiver. It's just, okay.
They have up to 30 days to come get you, right? Because it's a pre-signed waiver. You have already waived extradition. I can't give you a bond. Even I thought that you were Mary Poppins.
I was just told that Harris County honors the 14 days.
You can,
Is what I was told.
are you listening to jailhouse lawyers?
No, I actually remember the last time you said sometimes we don't read the
I
fine
told
print.
you, don't listen to other people. When there's a pre-signed waiver, statutorily, it's 30 days. They have to come get you. The 14 days is really 30 days. We do it as a courtesy. So in reality, it's 30 for everyone.
Sure.
We just, because we have so many people in jail, as a courtesy, we give 14 days. Okay?
Thank you.
All right, thank you. So he's reset to 5-1? Correct. Okay, thank you, Judge. Appreciate it.
You're the best, Ricardo.
I'm here on Tomas Nava Jr., NAVA.
Okay.
There's a BVR on this case. I've spoken to Mr. Nava about what's going on in his life and everything. So the allegations of the.
Where is Mr. Nava?
He's right here.
Come up.
The allegations are that there was one test where he tested positive for alcohol at a 0.04 and 0.05 level, Judge. I've spoken to him and made explicitly clear that there's no tolerance, especially in your court, Your Honor, for any alcohol at all. This is the only positive alcohol test that he's had in the 5 months or so that he's been on bond in your court, Your Honor. He's clean now, has been clean, is not drinking.
Am I supposed to take that for?
No, but if he were to be tested for ETG or anything today, he'll be clean, Your Honor. He's
There
been,
was a skin test between February 24th and March 31st.
sure. So I've also spoken to him about that. I'm trying to see what we can do.
DWI second, I've ordered you not to use. You've skipped 18 tests and now you're testing positive. Am I supposed to just let you go?
I would ask that he be released. He's gotten a new job, Your Honor. So his dad just got his legs amputated, Your Honor. He's been trying to take care of his dad, which is what's been going on in his life. And he's the main caretaker for his father.
These are things you think about when you're on bond for DWI second. We've ordered you not to use. Actually, it's his third DWI because he's had one dismissed. Oh. I don't know what I need to do to get a hold of you. You know, it's unacceptable.
And I've explained this, like I said, I've extolled all of these, these values to him and talked to him about this, especially in the wake of the BVR being issued to him. And how important it is that he can't miss a single blow. And, I'm telling him, and I have told him and admonished
Send him
him.
for a test right now.
Yes, sir.
Come back. Okay, let's go, Felicia. Let's send him.
Yes, Judge.
Okay, if he has to come back, then we'll talk.
Yes,
He
sir.
comes back.
Thank you.
All right, great.
This right here is a judge's breaking point. No more excuses, no more failed drug tests, no more endless drama clogging up the court. And check this out. He slaps on a Scram ankle monitor, a 24/7 alcohol detecting device that never sleeps. Imagine living with technology that tattles on you every single time you take a drink, with zero margin for error. It raises a bigger question. Does this kind of constant surveillance make justice smarter, more protective, and fair, or does it simply make the system scarier, colder, and harder to escape?
So Mr. Nava, his UA came back negative. I spoke to Truth
Come up, Mr. Nava. I'm now placing a device on your ankle that's going to tell me if you ever test positive again. If you ever miss, if this battery dies, so will your bond. You test positive for alcohol, guess what happens to the bond?
Yes, sir.
Do you understand me?
Yes.
Excuses.
Right.
I don't give a rat's behind about excuses. I don't care what you tell me. You've been admonished at least twice not to use. So for you to come in here and give an excuse or give an excuse for the missed blows, it's disingenuous.
Yes, sir.
And I'm not going to take any more. Do you understand?
Yes, sir.
Okay, so he'll have the Scram device today.
Want to get rid of the portable?
No, he's going to keep it.
Yes, Judge.
Okay. All right, Craig.
As
We're done.
far, the Scram monitors 24 hours. We're just gonna ask those, we're gonna keep the portable plus the Scram. Scram is.
This case is 153 days old. What are we doing with it anyways?
So we're waiting, so we signed the blood discovery order today. We're waiting on the state to talk to the witness, I think, involved in the accident.
This case is way too much drama for me.
Sure.
So in 30 days, it's clear trial. I'm not going to wait anymore. You're just way too much drama for me, Mr. Niles. So I'm going to set your case. By then, it'll be 180 days. By that time, it's clear trial.
Did y'all get a hold of anybody?
No, our Spanish speaker called the complainant and he got voicemail, and did not get a voicemail.
So I would send it to the investigator now so that we don't wait anymore, please. But 30 days, you must be back here ready for a clear trial. Do you understand?
Yes, sir. Yes, sir.
I'll take off the portable device. But once he gets the Scram device, then we'll take off the portable device.
Thank you.
And back in 30, clear trial.
Yes, sir.
All right?
Thank you.
I don't know if Chad's gonna post today, but his client's here.
Oh,
He said he was supposed to be approachable soon, his attorney.
come up, Mr. Villasana. He picked up a new case. Homeboy picked up a new case? Go. In the box. So I don't know what to tell you, but I'm going to have to appoint someone in the interest of justice because have you reached out to Mr. Henderson? He's just so busy. It's hard to.
We had a conflict, he tried to reset it, and I told him, his office that I couldn't reset it.
He's picked up
It
a new
was sent by
case.
you and I couldn't. reset it.
So appoint him someone now if you don't mind, please.
Judge, the BVR spur is too late.
Who?
There was some.
Well, he picked up a new.